So the Supreme Court took the case up, and at first the oral argument was very much against the city of Euclid. And the attorneys for Euclid asked for another opportunity to answer some more of the questions and to have further argument, primarily because one of the judges was absent. And they got a last minute stay. I mean, I tell the story in the book about after the first oral argument, the attorney taking a train ride home in the snow and realizing he had to pen something on the train, and he threw out a brief to the Supreme Court with a dollar bill or $10 bill attached to it, hoping that the person at the train station would pick it up and see that it was had instructions to send this to the Supreme Court by telegram. If the word got through, he had a second oral argument and he won. And what the Supreme Court, by the conservative Justice Sutherland, said was that, building an apartment building in a residential neighborhood is kind of like a nuisance. It's a wrong place. It's the right thing in the wrong place. And he characterized it like a pig in a parlor, that building apartment buildings in a residential suburban neighborhood is like putting a pig in a parlor of a home. And of course, pigs were also a term for Polish Americans at that time. I don't know if the Judge Sutherland meant to say that as a slight or not. But he basically talked about the thing that happens when you have this mixing of classes and how an apartment building is going to take away the light and air. And it's a parasite, his words, parasite on the community. So he was very much against the idea of using the Constitution to strike down zoning. And despite what had happened when the Louisville Ordinance was struck down in a case called Buchanan versus Worley, despite that decision, he upheld the Euclid Ordinance, and he basically upheld economic or class-based zoning, and that has been with us till this day.